I explain it to clients that when they file, they understand probate. People understand that when someone dies, there's a probate estate. And everything goes into the probate estate, and then we start taking things out of the estate. And we take out money to pay the funeral and the last illness. And this diamond necklace was supposed to go to niece Susie, so that comes out. And this goes out, and $5,000 goes to Wisconsin Public Radio, and this goes to Catholic Charities. And whatever's left goes to the heirs. Well, the bankruptcy estate is somewhat similar to this. Virtually all interest of the debtor, legal and equitable, go into the bankruptcy estate. But there are a few exceptions. One exception would be an interest in a spendthrift trust. So one of the things that you're asking at an initial meeting is, are you likely to become entitled to anything by inheritance in the near future? Is there anything you're likely to get? Okay? And then I don't stop there. I ask, well, how old are your parents? What kind of health are they in? Things like that. Is there anybody else who might leave you something? Because if that's the case, then I'm not an estate planning lawyer, but I have language they can take to mom, to take to her estate planning lawyer, to get a codicil added to the will that says that my client, the debtor, does not inherit anything. Instead, it goes into a spendthrift trust, because a spendthrift trust is one of the few items that does not go into the bankruptcy estate. And if it's not in the estate, the trustee cannot liquidate it, and it cannot go to creditors. So that's a good thing. Another one would be ERISA retirement accounts are not property of the estate. And finally, the question that came up during the break is college savings accounts, 529 accounts. And they're a little bit trickier, and Kris foolishly didn't bring a bankruptcy code. I'm blaming her. So neither one of us brought it, so I can't tell you the exact amounts because I don't try to memorize all the numbers in the code because they change. But it's a two-step process. If the money in the EdVest or college savings account has been there more than 2 years, it will not be property of the estate. If it's been there 1 year but less than 2 years, the amount that's not in the estate is about $5,700, something like that. I don't remember the exact amount. And if it's only been in there 1 year or less, it's just in the estate entirely. So the question was, what do I have to do with a college savings account if I'm filing bankruptcy? Well, the first question is, what exemptions are we using? Are we using state or federal? If we're using, well, it really doesn't matter. If it's not in the estate, we don't even have to exempt it. Because it's not in the estate. We only exempt assets that are, is that number in there?
You've got it in your book.
Yeah, it's page 12.
Way to go.
12, right.
How close was I on the amount?
You were okay, sort of. About $1,400 off, that's all right.
I'm okay with that.
And
all
it's $6,425. The exemptions are in your materials starting on page 10.
And by the way, I've used this chart for a long time. I find it really helpful to me to have a chart that compares the Wisconsin exemptions to the federal exemptions. The general rule is you're going to use Wisconsin or federal exemptions when there isn't much. And that's because the federal law allows a wild card, which you'll see in there. And so it's really nice to be able to exempt things like tax refunds, especially this time of year, tax refunds and cash. So we can exempt those with a wild card.
I like it better too with the homestead. I found that it covers more of the house than the state did on certain.
You're my household goods, not homestead.
Not homestead, excuse me.
Yeah.
Household. It does a really good job with that.
Mm-hmm. So most VLP clients will be able to use the federal exemptions. That makes it pretty easy because you don't have to finagle, you don't have to delay. This time of year, we always got to be asking about tax refunds because trustees will try to glob onto them. And some people get sizable tax refunds. They're not something we want to lose. So I find that chart, and I try to update it every time I do a presentation, so I think it's all current. And there's a couple references to cases in there because we've had a couple of important exemption cases in the last couple of years in the Seventh Circuit involving Wisconsin exemptions, which brings me back to the college savings account. At one time, we always told people EdVest accounts, which is the popular nomenclature. were safe. A good place to put your money that's going to be exempt, you'll get to keep it. Then there was a decision called Bronk, which brought that into question, and it went up on appeal to the Seventh Circuit. So we went through about 18 months waiting for the Seventh Circuit to issue a decision. We didn't know if EdVest was safe or not, but now we do. So we're back to EdVest being protected. So if you have somebody with money in a college savings account, it is exempt under Wisconsin's exemptions. There is no, under the federal law it's not exempt, but it might not even be property of the estate if they've had it long enough. So that was a really good question. It would have been deserving of a blue orb had it been asked in public. All right. What was the other thing I wanted to? Oh, property of the estate. So that's how we think of property of the estate. Everything that's in the estate, one of three things will happen to it. It's either exempt, and it's going to come out of the estate and go back to the debtor. That's that no asset report. Or it's encumbered, so my 2004 Toyota is worth $2,500 and the lien is $6,000. That's totally encumbered. There's no equity for creditors or the trustee. That's going to come out of the estate. It's going to be abandoned. That's the term of art. The trustee is abandoning that asset. So the trustee is going to abandon everything that's encumbered that he can't sell to get money, and the trustee is going to abandon everything that is exempt because she can't take it away from the debtor. What does that leave? That leaves non-exempt assets. It is the non-exempt assets, unencumbered, that remain, and those, there are no heirs, but those get distributed to creditors. That's what happens. That's the whole process with property of the estate. So ideally, we don't want to have property in the estate, but that's pretty hard to finagle. There isn't a lot you can do except with inheritances and college savings accounts. That's about it. And the college savings accounts requires a lot of foresight, 2 years, more foresight than most people have. Rarely, not that we haven't stalled that long and longer, we do sometimes, but most people can't wait 2 years to get relief. We had another question here on dischargeability of taxes. And the answer is, actually it's the answer I always give to my paralegals when we ask me a question. Anybody know that answer? It depends, yes. That is, there is no question clients can ask us that we can't answer it depends to. It's a wonderful thing.
You're giving him the orb?
No, that's not an orb question. That is a kill Bambi's father question. Oh. So the answer is it depends. And it depends on a lot of things. Okay? So first off, what kind of taxes are we talking about? Are we talking state? Are we talking federal? Are we talking payroll taxes, sales taxes, income taxes? And I'm just going to give you the broad general rules today because we could spend 3 hours easy just talking about taxes. So, general rule is that trust fund taxes, things like sales taxes and payroll taxes, Social Security and withholding, are not dischargeable. But general rule is that all taxes are non-dischargeable. What we're really talking about is exceptions where you can discharge them. So you can discharge income taxes provided they are old enough. And there's going to be, I'm going to give you a 4-part test in order to discharge income taxes. And I hope I remember them all. 1, the taxes have to have been due more than 3 years prior to the filing. So we are in November of 2016, which means that the 2012 taxes were due in April of 2013. But like so many people, I get an extension which kicks my due date to October of 2013. That means that was my due date if I got an extension. 3 years from October of 2013 was last month. So if I owe 2012 income taxes, even if I ask for an extension, I met the 3-year rule now. That means that 2013, 14, and 15 are not yet dischargeable. They will become dischargeable 3 years later. So 3-year rule. 2-year rule. The returns have to have been filed at least 2 years prior to the bankruptcy filing. Is there a presentation on taxes this year, Maggie?
This afternoon.
Okay, so you'll get a lot more detail on this afternoon. And the third rule, number 3, is the 240-day rule, which says that the taxes have to have been assessed at least 240 days, roughly 8 months prior to the filing. That's the tricky one because no client that you ever meet will know if their taxes were assessed or not, unless they have a notice from the IRS, tax lien notice. So in order to find out these things, never rely on your client. They will not know when they filed their returns. They will not know. They won't know anything. They'll never know when they're assessed. So you have to get tax transcripts. And this afternoon, I hope you come because, is Phil doing that? Phil Rosenthal?
No, he's not.
Okay, well, whoever's doing it will be fantastic. And they will be able to tell you how you get tax transcripts. It's not hard, but we don't have a lot of time to go through all that.
Ed from our the low-income taxpayer clinic will do it, so he does.
Good, good.
A difference though, tax transcripts generally are, when you're ordering them, usually what you want to get is an account transcript.
An account, I call them that, but you're right. She won an account transcript, okay?
Tax transcripts might end up with you getting just a transcript of your client's tax return, but you've already got that in your file. You want an account transcript that shows you it lays out for you how the IRS is handling payments, whether there's been any federal tax liens. It also has when the taxes have actually been assessed.
So you cannot get transcripts from the state. They don't have them. So what you want to do with the state is call, I hope he appreciates this, you want to call Hiram Cutting at the Department of Revenue. Hiram will really appreciate getting all your calls. But he's a very nice guy, and he can tell you when taxes were assessed. I just did a presentation at the Solo and Small Firm Conference on malpractice in debtor-creditor work, and taxes were one of the topics because it is a recurring theme that we as lawyers screw up figuring out when these taxes are dischargeable. We've defended lawyers on those claims before. We see them almost every year. Wilmick will tell you that they have claims every year on screwing up the tax debt. Tax dates as to dischargeability. It could just be a clerical error that you don't count right. So double check it. If you're not sure, ask another lawyer to look at it for you as well. Ask the low-income clinic people to do it. Ask me to do it. Anybody can do it. And then the fourth element, so the first three elements are all time-related. 3-year rule, 2-year rule, 240-day rule. And then there can't be any tax fraud involved. It can't be a willful failure to file tax returns. So if you get one of the posse comitatus people, and I've had them, and you probably see them in your neck of the woods, they may have a problem, even if they meet all the other tests, because they can't write in on their return that U.S. currency is bogus and I'm not paying until you apply the gold standard or something. That will make that debt non-dischargeable. And there's a really hot topic right now that I'll tell you about, but I don't know the answer. There are several circuits, 1st, 2nd, and 10th Circuit, I believe, have all now held that a return that is filed 1 day late is treated as though it was never filed, which means you can't satisfy the 2-year test. The 7th Circuit has not ruled on this, and it makes no sense. Even the IRS does not even take that position. But there's one circuit the 10th Circuit has gone the other way. Not the 10th. I don't remember which circuit. There's one circuit that says it's okay. 3 have now ruled, though, that a late filed return will make it non-dischargeable. In the 7th Circuit, we have a case called Payne, P-A-Y-N-E, and Payne says, in Payne, that the tax authority filed what they call a deemed return. So if I don't file my tax returns and I go long enough, the IRS can file a return for me. And that, the 7th Circuit said, does not count as a return. But we don't have a ruling in the 7th Circuit about this 1 day rule. I don't think it makes any sense. If it gets to the Supreme Court, one would hope that they say that doesn't make any sense. But it is a really hot topic in bankruptcy circles right now.
And the account transcript that you would get from the IRS will tell you if they filed a return on behalf of the debtor. So if you have the clients who just go, I don't know, I mean, the account transcript will let you know whether the IRS had filed a substitute return.
And these rules about dischargeability of income tax apply both to state and federal taxes, income taxes. Now, there is no, again, you will not get out of sales tax. You will not get out, bankruptcy will not get you out of payroll taxes. So there are other ways of dealing with those. We do a lot of tax work in our firm. I don't prepare taxes. I don't challenge whether or not the amount owed is right, but if you owe it, I will help people get out of it. And there are strategies for dealing with that, yes?
The last one that was done there was like an overpayment of UIC benefits. So
Unemployment would be non-dischargeable as well. Now, what is interesting, though, is that workers' comp, DWD claims are generally non-dischargeable, but some of them are treated as excise taxes. So it gets a little complex. So workers' comp, generally non-dischargeable, but it will fall within the 3-year rule. So excise taxes fall in this same 3-year rule that I just talked about. Also, UEF claims, uninsured employee fund. Anybody run into those? So if you're an employer and you don't have workers' comp and the state pays, those fall into the 3-year rule as well. And this.
talking a regular W-2 debtor who at some point received a notice from the state that they got unemployment insurance compensation benefits that were not.
Oh, okay. Well, what's going to happen there? So the question is, somebody was getting unemployment and they shouldn't have gotten it. And generally what's going to happen is that's going to be, when we talk about those 5 things to think about, that's going to fall under the dischargeability issue. The state will not, I don't know, it's fact intensive, of course, you know, why did they get these? Usually the state is going to come in and object to the dischargeability of that debt, claiming that it was some sort of fraud, misrepresentation. And usually they're right. Not always. It's possible it could just be a clerical error and that, you know, your client did nothing wrong. Usually, though, my experience is my client should have reported something and they didn't. They weren't necessarily being intentionally fraudulent. They were probably just negligent. But that will be.
He'd fallen, and he was a welder, and he had regular work where he would be cast out through the local, down in Ocean County, and he would, so that technically all of his stuff came actually from the local, so all his payroll information was reported vis-a-vis the local, so he had maybe 20 jobs.
By the local, I mean the union?
The union.
Okay.
So that he had maybe like 20 jobs, because he would be on different sites all the time. He fell, he couldn't work, but then he was like, he would be working for like a week, but then off, and then working for like a week, and then off, and he was notifying him that he was working. But because you're already experiencing a 2-week delay in actually getting your benefit when you go unemployed, so it wasn't directly attributable to, it wasn't like a workers' comp injury where he was subsequently receiving some
Right.
benefit. It was an unemployment, couldn't work.
You know, there's Andy Russbaum, I think it's Russbaum, over at the Department of Workforce Development, who is usually the one who files adversary proceedings on behalf of the Department of Workforce Development for things like that. That maybe, and he's a very reasonable person to talk to, that maybe talking to him, he generally is the one who handles those kinds of claims on behalf of DWD, and more about the facts kind of thing. But generally, they bring it at an adversary proceeding. I've had that where they're willing to work out a payment arrangement with my client. They don't, you know, where we work out, they look at the budget and they're willing to work with the client. But if you're challenging whether it should be non-dischargeable, he might be a good resource to follow up with.
He might tell you if they're going to challenge it. And again, it's going to end up being fact intensive because they can't just, an adversary proceeding that Kris is talking about is a lawsuit within the bankruptcy case. That's what we call our lawsuits in bankruptcy. You know, anybody here know the difference between a litigator and a bankruptcy lawyer? Bankruptcy lawyers go to court. We go to court a lot. Litigators do depositions. We actually go to court. So an adversary proceeding, though, is what the code and the rules call a lawsuit within a bankruptcy case, and just so people know what you're talking about.
Right, sorry, I didn't.
So it's going to be fact intensive there. They have to prove their elements to get that, and I can't really tell from this how that will turn out for you. So that pretty much, taxes. Did I leave anything out on taxes? Oh, one other thing. A lot of people here probably do family law. Just a comment about taxes and family law. The IRS will not, but the Department of Revenue will honor what your divorce judgment, how it allocates taxes.
Just came across.
Okay, so that's a really important fact for family lawyers to be aware of, because if the debt is assigned to one of the spouses, the Department of Revenue honors that. Now, they can only honor it for state taxes, of course. The IRS does not honor that. But there are innocent spouse rules and things that are way beyond what we have time to talk about. Okay, one other question here. There's a really good question here. Filing by one spouse and not the other. What's the effect on joint debt? What's the effect on debt prior to marriage? I'm going to be doing a joint presentation with the family law section sometime next year, and we're going to spend half a day on this topic. But it is an important topic. And I'm going to give you the 10-minute overview about family law. 5-minute overview?
No, I want to just bring it to, we get a lot of cases where they're about to get divorced and they're deciding whether they should file the bankruptcy together or not is another issue.
Okay, well, let's see what they've learned.
Okay.
What's the answer? Should they file together or not? All right, we have a winner. You already got something, though. You have the bourbon glass. All right, but it's good. You see, they're learning already. This is fantastic. Okay.
Just to let you guys know, there is some divorce information starting on page 39 of the outline that he's.
Yeah, but I wrote that, so it's not very reliable. Okay. So here are the questions. I get referrals all the time. Family lawyers are my biggest referral source. My single biggest referral source is family lawyers. And they always want me to file the bankruptcy first. Always. They think that is the way to go. They are often wrong. Okay? They like it first because it's going to make the divorce easier. It's going to clean things up a little bit. So it's good for them, but it isn't always good for their client. So let's look at the various factors that go into deciding what should be done when we run into the happiness package. Anybody know what the happiness package is? That's divorce and bankruptcy together. That's the happiness package. Who couldn't want that? Okay. First thing I got to know is who is the incurring spouse. Most people, including a lot of lawyers, and the Supreme Court has had me give a presentation like this to our circuit court judges, even circuit court judges in Wisconsin sometimes think that because we are a marital property state, both spouses are liable for the debts. So if I incur debts, you, my spouse, lucky woman, are not necessarily liable for my debts. It is not true that we are both liable just because we are married. The incurring spouse is liable for the debt. There is an exception where a non-incurring spouse can be liable for the debt, and that is what we would call support obligations. And I don't mean support that I'm paying child support. I mean support of the family. Support obligations go way back in Wisconsin case law to a thing called the doctrine of necessaries. So you can go back, you can find cases 150 years ago talking about the doctrine of necessaries. And the doctrine of necessaries said that the husband, ladies, you were quite lucky back then, the husband was liable for the debts of supporting the family, the needs, the necessaries of the family. And the cases are all over the board as to what is a necessary. There are cases outside the norm. There's a case that says that a prom dress is a necessary. There is a case that says that an expensive sofa, and I did the calculations with inflation, so it'd be about a $3,800 sofa today, was a necessary because of the family's station in the community. Okay, I don't know what that means exactly. Not soft butts and needed a soft sofa, I don't know. Okay, but there are weird cases that say that necessaries are really broad things. Generally, what we find in modern case law is that necessaries are medical bills. There's a number of cases. St. Mary's Hospital has a few cases. There's a number of hospital cases which tell us that necessaries are medical care. Depending on what side you're on, creditor or debtor, you either want an expansive view or a restrictive view. What happened on December 1, 1986 was, anybody know? Marital Property Act. What do you got over there? Nothing? That's really good. All right, candy. There you go. Give that man some candy. He's hungry. Okay, marital property law came into effect December 1, 1986. What it did was it codified the doctrine of necessaries, and it expanded it to you. Women now are liable for necessaries as well as men. Yes. Okay? So, the support obligations are what used to be necessaries. And so the non-incurring spouse is liable for the medical bills, at least most medical bills. I don't know if it would count hair removal on my back. I don't know. But medical bills are necessary. So the non-incurring spouse can be liable for necessaries. Otherwise, only the incurring spouse is liable. So if we both sign the credit card application, we're both liable. If only I sign it, which often happens in marriages, that I'm just signing for everybody, only I am liable. Well, then why do people have this thought that both are liable? Well, it comes from how creditors collect. Because under our marital property law, I may be the only spouse liable, but if they get a judgment against me, they can collect from my interest in marital property, and marital property probably includes everything I own. So a judgment against me enables the creditor to collect from me and my spouse, including garnishing her wages. And because they can garnish the non-incurring spouse's wages or collect from her marital property, people tend to think that both parties are liable. But that is not true. It's only how does a creditor collect. So it's really important to know who is the incurring spouse. We've had situations where only one spouse even needs to file bankruptcy. And you probably have seen some of these too. One spouse has amassed a huge amount of credit card debt, probably without the other even knowing it. You know, it's the spouse that's home to get the mail and they can keep this secret. I've seen people, when somebody dies, is only when they discover that there's $130,000 out there on credit card bills. So that's a really important thing to find out early on when we're dealing with divorce or potential divorce cases. Do both spouses even need a bankruptcy? Because you sure wouldn't want to run somebody, even though I think bankruptcy is really cool and I told you all the good stuff at the outset, you still don't want to file one if you don't have to, if it isn't beneficial. So, incurring spouse. Next question. Should we file before or after the bankruptcy? And again, the answer is it depends. If we want to file together, we have to file while we're married. A joint filing can only be made by spouses. Now, how important is that? Probably not that important. For my clients, some of them are worried about the cost of a second bankruptcy. Well, okay, but that's $2,000 maybe, depending on the situation. Certainly we'll take that into account, but if there's a reason to delay and not do it, it's usually going to way offset that there are other factors far more important usually than the cost of an additional bankruptcy. But if we want to file together, we have to do it while we're married. Single spouse filing or joint filing. This gets really tricky, and you have to go back to the various things that we talked about. Remember my 5 elements, okay? Well, eligibility and residency, usually they've been living together. Not always. Not always. I have a case right now where wife lives in Illinois, husband here. But usually that's not it. But discharge can be an issue, and so can exemptions, and especially exemptions. So, how would this be an issue? If only one spouse files, only the filing spouse is a debtor. Only the debtor can claim any exemptions. So the case to read on this, if you want to see how bad this can become, is a case in the Eastern District right here in Milwaukee, Judge McGarrity's case. It's called In Re Morgan. It might even be in the materials.
It is in the materials.
It is in the materials. And Morgan's a really interesting case. It's kind of fun to read. Judge McGarrity she just retired from the bankruptcy bench. She's a very distinguished jurist. She's respected nationally because she's an expert on family law and bankruptcy. And everything I know I got from her. I stole from her materials. Okay, so Judge McGarrity in this case had a situation where the family lived here in Wisconsin. They're
Page
separated.
46. Sorry, page 46 is the reference.
Yeah, but I don't think I have the facts in there.
No,
So
but just-
the husband moves to Florida and files bankruptcy. And he does not claim the Wisconsin homestead as exempt. The wife and kids are living here. And the Florida bankruptcy trustee contacts the wife and kids and says, hey, I'm selling your house. And they say, you can't do that. You know, so Judge McGarity, you read the decision, you can tell she is pained by what she has to do here. She's a judge. She's constrained to follow the law. But it's obvious that she doesn't like what she has to tell this poor woman and her kids. And what she has to tell them is, your husband filed bankruptcy. He's the debtor. He gets to claim exemptions. You do not. He did not claim this house as exempt. Therefore, the trustee gets to sell the house. Could have been avoided had they filed together, maybe. Depending, again, she would have gotten to choose the exemption. She would have gotten to exempt at least some of the equity in the house, and I don't remember how much there was. So the problem with a single spouse filing, before you ever do one, is you have to look carefully at the exemptions to see if somebody is going to lose something. Now, depending on the facts, you might want somebody to lose something. This can be a sword or a shield. I can recall a case I had where I was representing the wife, and she wanted to file a single spouse filing because she wanted the husband to lose his Harley. Okay? She wanted to file bankruptcy by herself because she wasn't going to claim the Harley as exempt, and she knew nothing would hurt him more than losing the Harley. You know, aside, Harleys are an amazing thing. They're right here in Milwaukee, and my experience is that people with Harleys will come in and they will say, take my house, take my dog, take my wife, take it all, but leave me the Harley. And so this woman understood that, and he had to pay the trustee to keep his Harley, which she thought was just wonderful. I couldn't have been a better lawyer for her than making him almost lose his Harley, or at least have to pay for it a second time. But exemptions are really important. And there's a whole line of cases that we don't have time to go through all of them, but there's a line of cases that says that assets that are not divisible, like a car, the single filing debtor, that spouse, can claim up to the full exemption. Now, he only gets his or her exemption, not both exemptions. If both spouses file, you double all the exemptions. So that's why you have to look at exemptions and see, will the one debtor filing, while they're still married, be able to exempt everything? Or do you not care? Do you want somebody to lose the Harley? But remember, that may come back to them again in family court later. The judge may not like what that person did. So if it's a non-divisible asset, we have several cases on both the Eastern and Western districts that say that the equity in the car, for example, cannot be divided. You can't cut the car in half. So the debtor can claim the whole amount of his or her exemption, and if that's more than the value of the car, the debtor can exempt the whole car. On the other hand, there's a case in the Western District, in Ray Page, which is probably in the materials as well, Judge Martin decision, where it was a financial asset of some kind that could easily be divided, like a bank account or cash. It's easy. It's fungible. We can cut it, and you can have this many dollars, and you get that many dollars. And there, the debtor could only claim the one half. So it's really important to look at the exemptions and figure out what the consequences might be, because you probably, usually if they're working it all together, and if they're willing to do a joint bankruptcy, they probably are working together, so they don't want to lose anything. So there are a lot of other reasons to file separately, jointly, and I don't know if I have a summary in the materials or not. Yes, sir?
What about income, the 122, when you declare the threshold income?
Yeah, so that's one of the reasons that I was just alluding to file separately. We do a lot of high income cases in our firm, so we're dealing with the means test that we're really not going to talk about here. But the means test says that if you make X number of dollars for your household, if you're over the median, you might not be entitled to a Chapter 7 discharge. The government will come in and they'll spend thousands of your dollars fighting with them over whether or not you're eligible for a Chapter 7 discharge. Well, there's a trick. So I tell the story. I had a guy years ago, early on with the means test, made $250,000, household of 1, maybe 3 if you count his college-age daughters. And we were able to get him through the means test, making $250,000. How did I do it? Both his daughters went to a small private college up near Minneapolis where the tuition was beaucoup bucks, whatever that amount is. And in the divorce, we built in that he was ordered to pay their tuition. And that was such a large deduction. He was going to pay their tuition anyhow. He was their father. He was going to do it anyhow. We just built it into the divorce, and now he passed the means test. So a guy with a huge income that otherwise wouldn't have been able to do a Chapter 7 was able to. So it's what I love about bankruptcy. Maybe I love it about the law in general, but I do bankruptcy, is that we get to be creative. Bankruptcy, there's all kinds of really cool things we do. Every time Congress makes new rules, we get to think about new ways to get around them. So there's a lot of things to consider. Generally, if there's no assets to worry about and the income means test isn't an issue, fine, and they're both are liable, good, file jointly. On the other hand, a lot of times one spouse needs to keep the car and the other isn't going to get the car because in the divorce they're going to divide the assets. Well, the spouse keeping the car might want a Chapter 13. Remember my Toyota, my $2,500 Toyota with the $6,000 lien? In a Chapter 13, I can pay what the car is worth, spread out over 5 years, and make my payment really small and not pay $6,000, only pay $2,500. But a Chapter 13 is going to be 5 years. Why would the spouse not keeping the car want to be in a lawsuit for 5 years when they can be in and out in a Chapter 7 in how much time? Okay, who said that first? You. But you already have one. Oh. All right. Anybody else want to guess? Okay. Another reason would be a business. A lot of times you're seeing people and one of them is self-employed, the other is not. The self-employed person may be far better off without a Chapter 7, may need a Chapter 13. So when we're talking about should they file jointly or separately, it really is, it depends. And it depends not only on what they have today, but what are their plans for the next 5 years. What are they going to want to accomplish with their bankruptcy?
David, you have a question?
Yes.
David, what if you had one spouse, they had a right to an inheritance, but they don't know whether they're going to be able to exempt it or not because they don't know how much they're going to get. So would that problem be solved by filing separately?
Okay, so the question is, one spouse is entitled to an inheritance, somebody's already died, but we don't know how much. Very common occurrence. Because of marital property, this is the opposite of what I talked about with the debts, and it's a really good point, Carl. Thank you for bringing it up. We also have to look at what are the assets. In my household, everything we have is community property. Our parents have all died. They didn't leave us squat. So everything we have, we own together. Okay? But the most common form of individual property for people that have been married a while would be inheritances or gifts, because that is individual property and not community property. So when I incurred all that credit card debt and my spouse didn't, and you inherited money from Dad, provided you didn't commingle it with my stuff and you kept it apart, that's your individual property. So my creditors cannot get to your individual property. It gets a little complex, as you can see. And then there are tracing rules, because if you inherited a house and that was 10 years ago, and since then you've been using our marital assets to pay the real estate taxes on the house, there are tracing rules in the Marital Property Act that enable you, maybe, to figure out how much of the house is marital property. Now, in answer to your question, I don't want to file a bankruptcy. If I'm the one inheriting, I do not want a bankruptcy if I don't know how much that is. And if I am going to file a bankruptcy, it's going to be a Chapter 13 so that I can dismiss it later and when my inheritance turns out to be more than I can exempt. I told you exemptions are doubled. Both spouses can exempt it. But in your situation, the non-heir cannot exempt that inheritance because it's not the non-heir's property. Unless the testator left it to both of them. But generally that doesn't happen. It's left to, I leave stuff to my son, not to my son and whoever his bride might be at the time. Well, people get divorced,
So one spouse could file and the non-filing spouse.
So the non-inheriting spouse could file, and that inheritance would not be in the bankruptcy estate. So I don't know if that answers your question, but there are options, and that's and it gets kind of complex, but that's a really good question. We're running out of the good stuff here, folks. You're going to have to come up with good questions. Bambi's dad again. This is the metallic blue Bambi's dad. Yeah, take that with you hunting. That is a good luck totem. Stacia.
Talk about timing, like if they file together as spouses, can they not then get divorced for 5 years until the discharge?
If they file together, no, they can get divorced.
Then they can divorce.
Oh, you're talking about if they're in a Chapter 13?
Yeah. Or
Okay.
either one.
Well, all right. So what happens is, yeah, and it happens all the time because people really want to get rid of their spouses right away, but the family lawyers told them to do a bankruptcy first. And it may be a good thing to do. I'm not saying it's never a good thing. A lot of times if there's no problem, sure, file jointly. Save the filing fee, get it done. And then if it's a Chapter 7, they could just wait because they're going to get a bankruptcy discharge within
4 months.
Oh, you keep being first. You got to let somebody else get a gift here. So they could just wait. Or in a 13, they probably don't want to wait 5 years. I don't want to live with Krekeler 5 years. Are you kidding me? Okay, so they're going to want to do a motion stipulation for relief from stay for the purpose of allowing the family court to divide the assets. So what happens is,
I'm sorry, what if only one person wants the automatic stay and the other person doesn't? Does it happen or doesn't it happen?
so the two debtors, one of them wants relief from stay to proceed and the other does not. Well, then you're probably not going to get a stipulation.
And an automatic stay has to be by stipulation?
Well, I suppose the spouse that wants to proceed could file a motion for relief from stay, and the other one objects, and then you have a hearing, and the court will have to decide whether it should go forward. And I would have to guess that the the bankruptcy court will say, yeah, go ahead and get divorced. Now, I shouldn't have worded it that way. Take back that last sentence, strike that. Go ahead and let the family court divide the assets. Because the automatic stay, which, as you probably all know, happens automatically. Yes! Okay, really good. You're a good group. Good group. Okay, so when we file a bankruptcy, there's an automatic stay. It stops all collection activities. Creditors can't sue. They can't garnish. They can't write. They can't send bills. It all stops. But it doesn't stop most family court actions. So people can still get divorced if you can convince the circuit court that it's okay, because a lot of them don't think it is. Okay, but they can. You can dissolve a marriage without, the stay doesn't affect that. Paternity can be determined. Child support and maintenance can be determined. It can even be enforced if it isn't with an asset of the bankruptcy estate. What cannot be done, what is stopped with a bankruptcy filing, is the division of assets and debts. So the state court, the family court, can dissolve the marriage, but it cannot say you get the car and you get the dog. And it can't say you're responsible for Sears and you're responsible for Kmart. It can't do that. So that's why you need to get relief from stay, is if you want to do the property division. The family court can do just about everything else without relief from stay.
Then may I follow up? So if you have a post-divorce motion, that would be to try to enforce rules, but it doesn't relate to maintenance or child support, and then the other spouse files bankruptcy, are you stopped until they complete their bankruptcy, or can you proceed?
It's going to depend on what your claim is, and you're going to want...
It's monetary, but it's not.
Right, so what you're thinking about is some sort of, what's the word I want, equalization payment?
Yeah, okay, let's say.
Okay, that could be one, or it could be attorney fees that, call him the husband, the deadbeat husband has over-litigated this case. He's racked up a bunch of fees. They've been awarded to you or to you as the family lawyer, and that happens all the time. So how you're going to want to approach that is going to depend on who you're representing and what you're trying to do. So I'm going to give you a few rules. 2 rules. First, about debts, divorce debts in bankruptcy. One is any debt coming out of the divorce is not dischargeable. Any debt. Exception to that is in Chapter 13, debts that are not what we call DSOs, domestic support obligations, can be discharged in a Chapter 13. So there are 2 kinds of debts when we're talking about a divorce. There are domestic support obligations, which would be formerly alimony, maintenance, and support, child support. And then there's everything else. Okay, so there's 2 kinds of debts. Domestic support obligations, maintenance and support, are never dischargeable. Ever. No kind of bankruptcy. All the other stuff, the equalization, and I think this is what you're talking about, he has to pay her $7,200 because that's how you balance, make everything equal, 50-50. That is dischargeable, but only in a Chapter 13. Yet another big bonus for Chapter 13. There's a lot of reasons to use Chapter 13. So in a Chapter 13, that would be dischargeable. But you really need to look and know what the debt is and why you might want to challenge it if that's your goal. So I mentioned the over-litigation. There's a decision from about September 16th, less than 2 months ago, from the 7th Circuit called Trentadue. And in fact, I just finished preparing a blast to send out to all my family lawyers, friends, and referrals about Trentadue. Trentadue was an over-litigation case and racked up $50,000 in attorney's fees. The husband, who was the over-litigator, the overzealous litigator, was ordered to pay the wife's lawyer $25,000. He then immediately files a Chapter 13, thinking that it's not a domestic support obligation, so it should be dischargeable. Wife objected, goes to hearing. The trial court, bankruptcy court, found that it was a domestic support obligation. Even though it was attorney fees related to contempt and over litigation, the court found that a lot of this litigation was hurting the children, that his racking up all these legal fees for the wife meant that she didn't have money for the kids, and they made findings about this, and so said, no, it's a domestic support obligation. The 7th Circuit upheld that, went through an analysis of why this was appropriate. So it becomes, to a large degree, fact-intensive, and it is not always what the label is put on it in the family court. So the fact that you're preparing a divorce stipulation, an MSA, marital settlement agreement, and you call this maintenance doesn't mean that it is. The determination as to the nature of the debt is a question of federal law. So the bankruptcy court gets to look at that on its own and decide whether or not, despite the label, that's one factor the court will look at, of course, they look at what is the real intent of the parties. So the fact that we call it maintenance or we call it a property division, either way, is not necessarily conclusive. I had a case a few years ago. I'm representing the wife, and the divorce judgment was very clear that this was an equalization payment. He filed a Chapter 13. I'm telling her, oh, I don't know, I think you're screwed. But we got talking. You can never ask enough questions. Somebody was talking to me at the break about you can never ask your client enough questions. We discovered in our conversations that yes, she had agreed this was an equalization payment, but there was a string of emails leading up to it that said, I'm going to forego maintenance in return for this. So we were able to convince the court that that was really intended to be maintenance, despite what it was called, and she got $19,500 that she wouldn't have otherwise gotten. So there's no hard and fast answer, and I don't even know what the question was, if I answered it or not. Pardon? Transfer?
Trent-A-Do.
Oh, Trent-A-Do. If you give me your card, I'll send you a copy and I'll send you my little analysis of it. But Trent-A-Do is Trentadue.
It's on page 49.
It's in the materials? How'd I get it in there that
Well,
good,
there you go.
fast? It just came out in September.
Thank God we update these things, Dave.
Yeah, well, you know, that proves one thing. It proves that we don't just reuse these materials. Okay.
Yep.
What have I not covered about divorce and marriage? Because that comes up constantly. I guess that's it. So let's talk, you know, I mentioned chapter 13. Let's talk about some of the reasons that chapter 13, usually I spend a lot of time talking about that, and we didn't today. But in the materials somewhere, I have a whole host of reasons why you might want to file a chapter 13 instead of a chapter 7, but without my glasses, I can't even read the
I'll help you.
materials. All right.
Well, we're starting the chapter 13 materials start on page 27.
Good.
of
Thank you,
the-
Kris.
Yep, of the outline.
Right.
There's a lot of different reasons, whether I don't know that we've given, well, I guess within the outline we've given reasons as to why we filed a chapter 13. You know, one of the reasons that we've got listed there is just the desire to pay. You know, there are times where you want to go ahead and pay your creditors, you know, and you just can't do it you need that 5 years, okay, because you'll see in the materials, and we probably unfortunately won't get to it today, but there is that chapter 128 procedure, really simple procedure in state court, $31.50 for your client to just be able to file an affidavit of debts and pay whoever he chooses to pay without interest, but it has to be done within 3 years. So the chapter 13 gives you that 5-year period of time that you may need to take care of all of that debt.
That was a really good question.
So
Do you know what that
that's
is?
one reason that people file a chapter
Bubbles.
13. Another reason that people file a chapter 13 is that they need the opportunity to get caught up on their mortgage payments. This happens, I mean, we deal a lot with clients who are faced with a foreclosure action. They had a job situation that caused them to not be able to pay their mortgage payments for 6 or 9 months. They absolutely want to keep their home, and whether they should keep their home or not is a whole discussion over here that we could talk about easily for another half hour. But assuming that you agree with your client and we agree that they're going to go ahead and keep their home, that's another reason why people use it, because then what they'll do, so let's easy cutoff. So they file their chapter 13 on December 1, 2016. They've got mortgage arrears that accumulated all the way up through November of 2016. Now in December of 2016, they start making their regular mortgage payments, so they don't let their mortgage payments get behind anymore, but they have that 3, 4, or 5 year plan to be able to take that $10,000 that they fell behind in mortgage payments and stretch those out over the period of time in your plan. So when their plan is done, they're back to status quo with their mortgage lender. Another reason that we find, again, related to real estate and keeping the home that we have that is developed is the opportunity to strip the second mortgage lender. This can become very valuable for clients. I had a client recently. Her home was worth $100,000. She owed the first mortgage lender $120,000. There's nothing there for the second mortgage to attach to, right? We have to bring that mini lawsuit that we described as that adversary proceeding. The debtor brings the adversary proceeding, asserts in the complaint the facts that I just gave you with a little bit more. The loan was taken out, we got the mortgage, this is the current value of the home, this is the current balance of the first mortgage, there's nothing left over for the second mortgage lender. You do have a situation where the second mortgage lender might challenge you on the value of the home, but assuming there's not $1, okay, for that second mortgage lender to grab hold of, that second mortgage lien can be stripped in the Chapter 13 case. Now, the only way it stays stripped, all right, is for your client to finish their Chapter 13 plan. All right, you have to make sure that they're able to go ahead and complete their Chapter 13 payments and get a Chapter 13 bankruptcy discharge for that second mortgage to be gone. But that second mortgage for some clients are $60,000 or $70,000. It's a significant amount of money to strip. stay in that Chapter 13 and get relief from that, and then be able to go ahead and then you record that release, and now they just have one mortgage on their home. Another reason that people more recently have filed Chapter 13s is, let's forget about the lien stripping for a second, but just going back to that first mortgage lender, for whatever reason, they've gotten that mortgage arrears up to a level that even a Chapter 13 plan for 5 years can't save them from. Their cash flow, their budget does not allow them to be able to continue to make the mortgage payment and make a plan payment sufficient enough, large enough, to catch up with the mortgage arrears. A few years ago, about 5 years ago, and then about 3 years ago, both Eastern District and the Western District have included what they've now referred to as a mortgage modification mediation program, where you file your Chapter 13 case. Your plan states that you're going to file a motion requesting that the mortgage lender participate in a mediation program. Mortgage lenders, for the most part, have been really surprised, no matter how far along the foreclosure action was prior to the bankruptcy filing, like we're just shutting down a sale, foreclosure sale. Many of them are willing to participate in a mediation program. They are not required to. That's the club that the bankruptcy code does not have. The bankruptcy courts have decided to give this mediation program, give the debtor another kick at the cat, to get this mortgage lender to come to a table and mediate the overall debt. But there is no club. If the mortgage lender refuses to mediate, there's nothing that the court can come in and submit an order and force that mortgage lender to mediate. But it has been very significant for a lot of clients as far as being able to walk out of that Chapter 13 case with their first mortgage modified at a level now that when they're done with their bankruptcy case, and there's some rules related to how long they have to stay in the case once the mortgage modification has actually been approved. They still have to be in their case for at least 9 months. It's kind of that good faith. I'm making my payments under the loan modification before they're allowed to be out of the Chapter 13. But it can be another thing that's very significant for the debtor to be able to use the Chapter 13.
And some people get really low interest rates, 2%.
40-year
3%.
amortizations. I mean, it's really been
Some
amazing.
write off a principal, so it can be a valuable tool.
Right.
Another reason for Chapter 13, the municipal judges, by the way, I did a presentation for them about bankruptcy, and I was amazed. I didn't know it, but they say they hardly ever get notices on all their citations and tickets and things. And it occurred to me that we probably don't ask that enough either. Right. So another thing to ask your clients about is, do you have any parking violations? Do you have citations? You probably wouldn't file a Chapter 13 just for that for most people, although every now and then you read newspaper articles about people that owe lots and lots of fines and citations, because those debts are dischargeable only in a 13, not in a 7. So Chapter 7 has a broader discharge. And we already talked about the big one, which is the divorce obligations. Another one that you might run into from time to time would be conversion. So we do a lot of farm work, and somehow the cows, they must have died. And they're just gone, and the bank says that's conversion, and that's non-dischargeable. But it is dischargeable in a Chapter 13. So Chapter 13 has a broader discharge than Chapter 7, so that's yet another reason. Another reason, too, is the income tax debt. The debt that we were talking about that we can't get rid of. And an offer, I don't know if you guys do any of this, but trying to do an offer and compromise right now with the IRS is just almost impossible, because the IRS has just, all of the individual agents have just kind of, they're gone. But a Chapter 13 can certainly be used as a way for the debtor to get back in control of, instead of the IRS or the Department of Revenue, Wisconsin Department of Revenue levying their wages, stops that levy, again brings those taxes and allows the debtor to spread that liability over 5 years to be able to pay that at the debtor's budget, how the debtor's budget allows, versus being faced with those levies by the state or by the IRS for those income tax debt that could otherwise not be discharged in a Chapter 7. Another reason you can file Chapter 13s and get another discharge sooner. So anybody know how long, if I file a Chapter 7, I get my discharge, when can I get another Chapter 7 discharge?
9 years.
Who said 9 years? You're wrong. Who said 8 first? Back there. Okay, and we have a winner.
I gotta get rid of the orb. All right, finally,
You
I'll call
don't
it
get
an
you
orb.
don't get rid of the orb. The
I
orb
mean
is
it
not
that
something to
way.
be gotten rid of. This is the blue orb, and we have a winner. The blue orb. So it's 8 years. That's correct. But if you filed a Chapter 7 and you're in trouble and you need a bankruptcy again, you don't have to wait 8 years for a discharge. If you file a 13, you can do it sooner. 4. Correct. Very good. Oh, you already have something? Okay. What's
Here,
what do
can we
got?
give him that hat?
No, that's my hat. You don't want that anyhow.
No,
You know,
I'll let you decide.
when you're follically impaired, you need a hat when it starts to get cooler because you'll get a cold. You know? Here we go. Oh, this one's a Christmas glass, so if you don't like Christmas, I'll give you a candy bar, but okay. You know, I'm politically correct. Okay. So you can do successive 13s even faster, although there's a little bit of case law that questions how you determine whether the word filing means the same as discharge, so I won't go into all that. And closely related to how often you file is what I talked about earlier with personal injury cases, the ability to dismiss virtually at will. So in a Chapter 7, if I file it, I'm in it. It is very, very difficult. You will not get out of a Chapter 7. In all the years I've been doing this, I've only gotten one client who was able to dismiss a Chapter 7. And to do that, we had to give an affidavit to the court that we had paid every creditor in full. So you're not going to get out of a Chapter 7.
But what about a conversion?
Sure, you can convert from one chapter to another.
To a 13?
Yes, and that's almost, that will be freely allowed. But the ability to dismiss at will is a valuable tool. Remember my negotiations with the student loan? I can go and negotiate with them, and if we get a deal, I can just dismiss. If I filed the case because I have a personal injury claim pending and it settles, and I need to get a hold of that cash, I can dismiss. So a Chapter 13 can be, the ability to dismiss at will is a very, very valuable asset.
And the other thing too is the Harley situation, where a lot of times what we'll do is we'll protect non-exempt assets by filing a Chapter 13. And the reason it's called the best interest of creditors test, where you have to determine would you be required to pay your unsecured creditors in a Chapter 13 to protect that non-exempt asset. And so generally what happens is you look and say, okay, what assets would have been non-exempt and would a Chapter 7 trustee been able to grab and distribute to the unsecured creditors on a pro rata basis in a Chapter 7. So what the debtor does is he files a Chapter 13 plan that takes that calculation, that maybe that $7,200 Harley, and again, because it wouldn't have been protected in the Chapter 7, would have been liquidated and would have gone to unsecured creditors, retain the Harley, pay your unsecured creditors the $7,200 over the course of that 3, 4, 5-year plan. You get at the end of the plan, you've still got your Harley, and you ended up paying the unsecureds what they otherwise would have received if the Harley would have been liquidated in a Chapter 7, but that Harley was just so important to retain, or even the personal injury matter. Maybe there's other reasons why that debtor isn't going to dismiss the Chapter 13 because of other things. Maybe they have a huge amount of tax debt that the Chapter 13 is also trying to accomplish. So maybe they can use, depending on what that non-exempt portion of that PI claim would be, use that Chapter 13 to retain the exempt portion of the PI claim and pay the non-exempt portion of the PI claim over time. Because maybe they wanted the opportunity to use that non-exempt PI portion to pay that tax debt.
How sticky are they on the income requirement for that? That they're a wage earner?
That gets into remember my 5 rules. One of them,
Right.
the very first one was eligibility.
Right.
So to be eligible for a Chapter 13, you have to be a natural person, and you have to have income.
Right.
Okay, so regular income, and that's easily satisfied though. So unemployment compensation would qualify, Disability qualifies.
Okay.
So it doesn't have to be wages.
Doesn't have
Social Security.
Social Security,
Yeah.
income from a Chapter 12 plan.
Income from a chapter. So I'm getting.
This client is a creditor.
Okay. All right. Creditor in at 12, so she's getting payment. I don't see why not.
She's getting regular, and this just
Yeah.
started.
And the courts are pretty liberal with this.
That's what I wanted
You
to
know,
know, right.
judges generally are going to favor debtors. If there's a case, you know, like a Chapter 11 or a case that drags on, courts eventually get sick of our clients. But generally, bankruptcy is there to provide relief.
Right.
And so you're going to find that the trustees and the judges are on the debtor's side, at least initially,
Right.
until there's some evidence of a lack of good faith. That's why we have the system.
Okay, because I have a client who started out in a 7, it's a disaster divorce situation where her ex has done 11, 12, an 11, a 7, now in a 12, got a agreed upon plan. Meanwhile, trustees decided, oh no, you didn't do this right, and we're just gonna take everything. Which, good luck finding, like you said, the cows and the machines. But she just recently, like Friday, got a first payment on a 12 that we thought would never come to fruition.
Yeah, I mean, if I didn't want her to be able to file bankruptcy, a 13, I'd argue that that's not regular income.
Right.
You know, I'm a hired gun. I'll argue anything.
Right, that's it. I mean, I can see where this is going, but at the same time, I'm trying to get her some relief because the trustee has just got to be in his bonnet. And so I'm trying to figure out a way to get her back in another direction, considering her ex has done 3 or 4 bankruptcies.
Well, keep
Right.
in mind what we talked about earlier when we were talking about the alternatives to bankruptcy. Depending on how much debt she has and who's pressing her, she might be a good candidate for a Chapter 128.
But you said that getting a 7 dismissed is next to impossible.
Oh, she's in a 7.
She's in a 7.
Oh, she's not. But she doesn't need to have regular income then.
No, I know, but the problem is he's gonna take, and you know, he's attempting to take because they aren't exempted. She doesn't live on the homestead.
So you're at what we talked about with the divorce. Yeah.
That's it, so I'm thinking 13, if we can do a conversion to a 13, because their debtors aren't all that humongous anymore, you know?
Right.
That as
The-
long as that amount is considered earned income, she's sort of disabled, you know, okay.
Yes, I think you
Okay.
can.
Okay, that's
Um,
thanks.
But sometimes in the scenario you had, I was misunderstanding what you had in mind. I thought she was paying. So, but a 128, how many people have filed a Chapter 128 before? Only a few? Okay. You can be proud of doing it. It's okay. You know, I think they're wonderful.
They're
So
perfect. I mean,
that
they're
can work
really great.
very well. In a Chapter 128, the debtor can pick and choose what debts to put in. That's an advantage. Whereas bankruptcy, everything is in.
See, and
Okay.
we didn't believe, this 12 popped up after we filed 7, after we had the first meeting, you know what I mean? Where we were just done. She had tried everything.
Right.
The civil court, you know, the whole thing. And then all of a sudden, the 12 pops up, and all of a sudden, this money appears.
But in a 128, if my client was being garnished by one creditor and can't afford not to get their paycheck, which often happens, let's say it's a $3,600 debt, and I've got a bunch of creditors, but only one is chasing me. A Chapter 128 might work fine because I can take that $3,600, pay it interest-free over 36 months, only $100 a month. The cost of doing it, the filing fee is like $27 or
$31.50.
The filing
Right.
fee is negligible, and the attorney's fees, it's not a lot of work. You can do one of these in 2 hours or less. Yes, sir.
The other thing that's really valuable about 128 is if they're about to get a judgment and they have real property, that judgment typically would end up with a judgment lien on it, whereas if you get into 128, now it's not uniform, but typically the creditor will dismiss the action, which would, if there were a list pending, it's going to eliminate the list pendants. They're going to probably have to make 6-7 months worth of payments because they're going to have to get a couple from the trustee before that happens, but I've used that 3 or 4 times. Especially when it was We Energies and they were a gigantic, ridiculous bill.
Right?
128s do not work on secured creditors only unsecured. So keep that in mind. You can't force a secured creditor to do this. But
This property was not a
Yeah.
property, they were aware, we understood
Okay.
aware of it, they were not.
The other thing you can't use a 128 for, I don't believe, is the debt owed to the IRS or the Wisconsin Department of Revenue. They
But
won't
the Department of
recognize that.
Revenue will probably go along with it if you're paying them over 3 years. You can't force them, correct?
Right.
Yeah, my experience is they'll go along with it, if, you know, because they're getting paid.
Well, but the problem with that is the no interest piece. I mean, even though the IRS is, I mean, the Department of Revenue is entitled to, I think, 18% interest. So that becomes, depending on the level of debt, that becomes a discussion with the revenue agent that's in charge of your client's account.
Driver's licenses. I'm going through in the last few minutes a few little things we want you to remember when you run into them. Every now and then you'll run into somebody who's violated our safety responsibility laws. So they had a car accident, didn't have insurance or enough insurance, and therefore, they didn't have insurance, period. And therefore, the motor vehicle department is going to yank their operating privileges and their vehicle registrations. And a bankruptcy filing will reinstate those right away. Now, they'll still have to pay the fee, but they can get their license back right away. And I think in the materials, we even have a sample of
We
the
have
letter
a sample
sent.
letter in, when we're talking about the appendix information, or I'm sorry, yeah, it's in the appendix information.
Why don't you tell them what's in the appendix, run through it quickly, so they know what to look for later that may be helpful.
Well, we have in the appendix, Exhibit A is the motion to avoid liens. So when we're talking about the avoiding of the liens of the tools or the non-possessory, non-purchase money interest in the couch or the car, you can use a motion to avoid fixing of liens that appear exemptions. We've also got in the materials the required list of schedules and statements and what the fees are, what the current fees are in filing a 7, 13, 11, and 12. In addition, if you have clients that have, I believe it's less than $150,000 of debt, there's a notice that you need to provide, which is on Exhibit D to the clients.
Kris.
Make sure that you do that. Notice of assisted persons.
Before you go on, that Schedule B can be really helpful if you don't do a lot of bankruptcy work. We didn't create this. This is I think this one is from the court's website. And if it's not, the court has one very similar. So if you go on, both the Eastern District and Western District have their own websites, and they do have forms with lists of everything you're going to need. So that can be really helpful. You know, we do it all the time, so sometimes we take it for granted because we've done so many. But otherwise, there's quite a few things you need. So that's a nice little checklist for that reason.
Right. There will also have on E is the payment advice cover sheet. That's the sheet that you need to use where you need to attach the 60 days worth of pay stubs that showing what the clients earned 60 days prior to the bankruptcy filing. You would use that, your client needs to sign that. We also have on schedule, I think it's F here, this is related to the means test. This is the most recent. They just changed everything on November 1. So the U.S. Trustee's Office has now increased the median income for the different household numbers. 1-person, 2-person household, 3-person, 4-person household. That was just updated on November 1. And those statistics, the median income statistic is
I don't think you'll have
F for
a
you.
problem with those with VLP clients because I think this is higher than what the VLP eligibility is. So that shouldn't be an issue.
Yep. Also, we have the reaffirmation agreement as part of the most recent form for the reaffirmation agreement that you would use in a Chapter 7 case if your client wanted to reaffirm their liabilities, such as their mortgage debt.
And we didn't talk about reaffirmations. Lots of debtors reaffirm debts. And the reason is bankruptcy discharges debts. It does not discharge liens. If it discharged the liens, every one of us would file because we get a free house and a free car. It'd be great. But it doesn't. So in order to keep the car, you have to pay for the car. In order to keep the house, you got to pay for the house. So a good way to do that is to reaffirm the debt. Sign an agreement that says this is still a legally enforceable obligation. And if you're not going to have your client reaffirm a secured debt, be sure you cover yourself in writing about that. And if you are going to have them reaffirm the debt, be sure you cover yourself in writing. Either way, put in writing to the client why they're doing what they're doing, because they will come back to you later and complain. So I put everything in writing. Kris can tell you, I believe clients should get letters every time anything happens. I just think that's good practice. Yes?
If you have a client whose like mortgage is really underwater and they don't want to reaffirm, they can't redeem, and they don't want to surrender, they just want to pay and see what happens, what do you put, like if it's like a ride-through situation, what do you put on a statement of intention?
There's an other, you would mark other, right? And generally what we put down is retain, if there's a foreclosure action pending and they just want to stay in the house as long as possible, we'll say retain until the foreclosure proceedings has concluded. Otherwise, generally, we would put something to the effect of retain until other action or something to that effect. You know, there's times though where the client, again, I guess if you can, some clients want us to try to use the reaffirmation agreement as a way to try to do a loan modification. On a practical standpoint, that just isn't usually what the lenders are willing to do in the reaffirmation stage. But I would at least put down retain until other action taken.
We are out of time. I have cards up here if you want to have free coffee with me anytime to talk about this stuff. You can have them. Thank you, Maggie.
Yeah,
Thank
thanks.
you to David and Kris.
No, you're welcome. You guys are welcome.